नहीं क्या? हाँ, थोड़ा उठा लेना। उठा लेना है थोड़ा। हाँ, और नहीं नहीं, बेसी थोड़ा बस। हाँ, ठीक है सर।
I
यस।
please your lordship. I beg to mention item number 8, lordship, on behalf of Mr. Q. Dutta, lordship. His father is sick to tell, lordship. He informed me to adjourn the matter on behalf of him.
Item number 8.
8, lordship.
Okay, 21 matter. GMC has been informed.
Already informed, he informed me,
Okay.
lordship.
This court has been informed that Sri U. Dutta, learned counsel for the petitioner, is having some personal difficulties, and therefore an adjournment has been sought for. List after 2 weeks?
Any date.
List after 2 weeks.
Oblige.
Please, the lordship, my lord, with due consent from the petitioner side, I beg to mention item number 14, my lord.
Yes.
My lord, in this matter, we have not received the complete instruction, my lord. So we pay
It is for orders.
orders, my lord, but the notice has not been issued to the private respondents yet, my lord. Only we have to file affidavit, my lord, and complete instruction. And the advocate for the petitioner, they have said that another similar matter is pending, my lord. So they want to take this matter along with that. I will give the number, my lord. Mr. B.T. Goswami, I talked to him.
Okay. Sri D.P. Bora, Learned Standing Council, Health Department, submits that instructions are yet to be received. Full stop. He has also informed this court that there is a similar matter being WPC number so and so. Full stop. Para. List this case along with WPC number so and so after 3 weeks.
Obliged, my lord.
May please, your lordship, I beg to mention a review petition for
Give the number, Mr. Bora.
Yes, my lord. I will collect from
Okay.
Mr. B.T.
Okay.
May please, your lordship, I beg to mention a review petition for listing, lord.
Review petition
Lord.
of this court.
Lord.
When do you want?
4th of April, lord.
4th of April. Day after tomorrow.
Yes. Okay.
I recommend, my lord, item number 8, 9, and 10, my lord, can make the adjourn.
8 has been already.
Sorry, 9, 10, and 11. Sorry, my lord.
9, 10, 11. Yes, what is the problem?
So some personal difficulty.
Of whom?
I am appearing on behalf of NJ Khatami. We are
Okay.
communicating with the client.
Yes, G. 9, 10, 11. Mr. Dhar? A request has been made on behalf. Yes, anything?
My friend is declaring, I will take the instruction, my lord. Clean up, my lord. Let it be, my lord. Let it come, my lord, reach the matter.
Okay, we'll adjourn it, but not now. We'll adjourn it. Let Mr. Nas come. Okay.
Obliged.
When the surgery comes.
I didn't want to go to this.
What is the matter about? Madam Kotoki, please call her.
Her name is not.
None appears for the petitioner on call. Para. The concerned department is veterinary and animal husbandry. Full stop. However, the name of the learned standing council of the department is also not reflected in the cause list. Full stop. Para. In the interest of justice, place this case on 4th of April 2024 to give the petitioner another chance. Full stop. Para. It is, however, made clear that in case of further default, comma, this court would pass appropriate orders as the instant writ petition is pending since the year 2015. Is pending, is of the year 2015. Yes, next.
Item 2.
Yes.
In this case, my lord, petitioner, my lord, want to get family pension, my lord, after the death of the bachelor's son, my lord. Now, he died on 2/12/2000 in the year 2000, my lord.
You are the mother.
Yes, my lord. She is the mother, my lord.
Okay.
Initially, my lord, first I filed one writ petition, my lord. That was not amended.
Hmm.
But subsequently, in my case, my lord, rule has been already amended. Even after the death of the bachelor's son also, mother, father, parents be able to get family pension. Now here, my lord, he worked from 3
Yes, yes. What do you say? Is there any dispute here?
My lord, two things. Here, there, if you go by the prayer, my lord, I don't have a brief, just I have gone for the thing. The quick point that I could understand, my lord. They are seeking first regularization. Regularization is, my lord, after Upendas, he was in
No,
work
he's restricting his prayer for family pension.
family pension man.
We are not for regularization. Is he otherwise entitled to family pension?
after more than 10 years of work.
10 years, my lord, in a regular employee, my lord, 2000 work, it will be covered by Sanchita Roy, I believe, my lord. That I just wanted to, my lord, check out once.
No, Sanchita Roy
Sanchita
is
is
for
required.
pension.
Pension.
Here, the bachelor's son has passed away.
Family
Post-
pension, yes.
Post facto regulation also required.
Can't, my lord. After Upendas, no regularization could be, my lord, given, my lord. The honorable division bench is very clear. You know,
No, Mr. Dhar, you are correct in one sense. If you bring in the concept or the law laid down in Upendas,
Both.
then the question of his regularization will not come. He'll get some benefits after his
benefits are,
retirement.
my lord.
Now, here the facts are slightly different. The incumbent has passed away. He has rendered more than 10 years of service.
My lord.
May not be in a regular
Not
capacity.
regular, my lord.
But
Certainly.
if you bring in the concept of Upendas, if he would have been alive, then he would have got some benefits after his retirement.
Well.
Now he is not there. Whether the same analogy can be also drawn for the purpose of family pension. Because bachelor son, unmarried son, parent's mother is entitled otherwise. How do you treat a matter of this kind?
My lord, for family pension even, it will be regularized, my lord. Regularization will come, otherwise, my lord,
No, even in Sanchita Roy,
my lord.
we have said that deduction
20 years,
20 years.
20 years, my lord, that bracket is there, my lord.
So for computation of 20 years, you cannot ignore the,
We will not delete that 6 years
yes.
cap, that is there.
Now 10 years is the required number of years period for being eligible for family pension.
My lord, my prayer would be, my lord, let matter. I will just, we don't have a file also, it's a very old case, my lord. Next week, any day, my lord, or my lord, this week.
No,
also,
had Mr. Dhar, had it been any other matter, our approach would have been different. No, our approach would have been different.
My lord, I understand, my lord,
But in spite of being this a fiscal matter,
my lord.
Here, the subject is wholly different, family pensions.
My lord.
And there is no denial that he has worked for 10 years, may not be in regular capacity. In these cases, how do you deal with as a welfare state? We'll have it day after tomorrow.
My lord.
You-
I will just make a photocopy of the writ petition, my lord, from my
You
pen,
can,
my
you
lord.
can put forward your point which you have already
Mile,
put, but
mile.
this is not very adversarial unless you dispute on the facts that some misrepresentation or incorrect facts have been placed. If the facts are admitted, maybe you can assist the court how this matter can be resolved.
My lord.
Yeah.
Only that regularization part that they are seeking, that has to, my lord,
Not regulation, family pension.
That part we are not.
Yes.
that part, my lord, has
That
to.
part is covered by
Yes.
open does. You are
Open
correct
does.
in that. Okay, heard 3H just learned counsel for the petitioner. What is the IA for?
I have for early date of hearing, it was,
Okay,
my lord.
okay, we'll have it.
It was, or it has been already disposed of, 7/6/17.
Is just learned counsel for the petitioner. Also heard Sri R. Dhar, learned state counsel. Mr. Who's? Three is whom? AG. Also D. Bhattacharya, learned standing counsel, AG. Full stop. Para. Do this matter is of the year 2015, comma, please her, the learned state council has prayed for a slight accommodation to enable him to obtain necessary instructions. Full stop. Para. Considering the above, comma, list this case on 4th Thursday. Mr. Das come.
Yes, sir.
Item 3. বাবা আমার তো সেকেন্ড হেরি মোশন অফিসার তো পড়ি নাকি
May it please. Lordship, herein this case, the petitioner initially was promoted to the junior grade to the
Who's for the UCO Bank?
my lord, Eco Bank. Earlier, my lord, my senior Mr. P.J. Stoikia, he was entered his appearance. My lord.
No, Mr. AJ Das, RK Datta, N Barua, MK Ali. AJ Das is Arubjoti Das. Who? UCO Bank normally who appears? M Sharma.
I'm sorry, my yes, sir.
M Sharma.
But
Can
in
you-
this case, my lord, as per my knowledge is concerned, my lord, Mr. P.J. Stoikia, senior in the senior council, who appeared, my lord, entered his appearance last time as
There
a
are-
senior council, my lord.
What is the matter? Department proceeding.
Yes, no, departmental proceeding not, my lord, the criminal proceeding was pending against the petitioner and his promotion was withdrawn. Once given, then thereafter withdrawn. Thereafter decided to keep in chill cover, my lord. The judgment has been passed in the criminal case. He was acquitted and thereafter the promotion was restored in the year 2015, which was kept pending in 2022 and 2000. my lord. But no benefit, no monetary benefit has been given. The benefit given only from the 2015 itself.
But you have not, if you have not worked in the higher post, how will you get the monetary benefit?
But my lord, as per the Janki Raman's judgment, my lord, so the monetary benefit has to be decided by the department or whatever may be, but reason order should have been passed, my lord.
Now, so far as your
Because-
so far as the fitment, other things are concerned, that should not be a problem. If, as you have submitted in the criminal case, you have been acquitted, and you have said that once promotion was given, it was kept on hold.
Yes,
That means you continued to work in the feeder cadre.
Yes.
Not in the higher post.
Yes.
So, but you were entitled in law to work in the higher post.
Yes.
Now, in the meantime, 15 years have passed.
Passed.
15 years, whatever position you would get, you should be considered put in the higher post, even post more than
he
that.
is already
but-
retired, my lord. Retired on 31
But
age.
so far as your fitment is concerned, computation of pension.
Yes.
those we can consider, but monetary benefit, Janaki Raman, does it say that you will get monetary benefit?
Two issues I have raised here. One is
But you may be right in contending that they have to take a call and say whether you are entitled or not.
yes,
Then at least we can
Yes.
examine.
yes, madam. That is one thing, and next thing is that should be given a benefit at the time of pensionary benefit.
Yes, that we can. Can you get Mr. Sharma or whoever?
My lord, fixed another date, my lord, better, my lord.
No, these are 15 matters.
Yes.
Try to locate Mr. Shah, whoever is appearing or who appears for UCO Bank. We'll try to dispose this of, if possible. Otherwise, we'll have it maybe immediately after Bihu.
Because
Because
my
after 4th, we have been informed
After
that
fourth, my lord, the quarter seven, I have to let my lord because for some personal
today,
duty. That's why.
15 matter, Mr. Okay, we'll say something else. Heard Sri R. Islam Learned Counsel for the petitioner. Full stop. However, the respondent UCO Bank is unrepresented. Do names of counsel appear in the cause list? Full stop. Para. In the interest of justice, matter is adjourned to be listed on
The date, my lord, today's
on 5th.
fifth.
On 5th, full stop. 5th. You try to locate.
Yes,
Okay, we
yes.
are not saying. anything is
I'll
not.
inform you. Much.
Lordship, for consideration of promotion to the post of inspector, I filed his writ petition. In the meantime, the petitioner has got the relief. Lordship, he was promoted to the post of inspector and subsequently he was promoted.
Inspector in police department.
No, the food civil supplies
Food and civil
that you have
supplies,
there.
okay.
And subsequently he's been promoted to the post of superintendent. Only, Lordship, his notional benefit, my lord, that has not been given to him, my lord.
Yes,
Lordship, may I kindly have a look at the instruction, my lordship, orders, my lord, which have been passed in favor of the petitioner.
the departmental proceeding has been closed.
Yes, my lord.
Yes, Mr. Goswami.
Ekon logo pare.
We got the instruction, Lordship.
Yes.
In that instruction, Lordship, it appears that Lordship, so far, Lordship, to release the area pay and allowances to the concerned officers, relaxation of the provisions of FR 17(1) FR and SR is required to be required from Finance Department. Accordingly, an e-file is under process for FPDCA department for obtaining the concerned.
This
Finance
instruction is of
Department
which date?
Yes, Lordship, it is 27 March, Lordship.
Last,
Recent. 27 March.
3 days back.
Yes.
Okay, we'll grant you some time.
Yes, Lordship.
In that case, we can close this petition on the next date.
Lordship.
May I get a copy of the?
Okay, heard. Ms. B. Bhuyalan, Senior Counsel for the petitioner. Full stop. Do the writ petition was structured with the relief prayed with a relief for promotion of the petitioner
Thank
to the post of inspector, food, civil supplies and consumer affairs, Assam, Ms. Bhuya, the learned senior counsel, has submitted that during the pendency of the case, the petitioner has been promoted to the aforesaid post and the departmental proceedings, which was also the subject matter of challenge, has been dropped. Full stop. The only issue which remains for consideration is the benefits to be given from the date on which the petitioner was actually eligible for such promotion. Full stop. Para. Sri Goswami, J.K. Goswami, learned additional senior advocate, Assam, has informed this court that as per our recent instructions received wide communication dated 27/3/2024, the matter is under consideration and is presently before the finance department. Full stop. He accordingly prays for some time for finalization of the matter. Full stop. Para. This court is of the opinion that if the remaining part of the issue is taken care of by the department, there may not require any further adjudication in this matter. Full stop. Para. Accordingly, in the interest of justice, the matter is adjourned to be listed on 26th of April.
First week of May, Lords.
Let us try on 26th. Today is
Lord,
26th of April.
Lord.
Is finance a party, madam?
Lordship,
Since, yes, Mr. Chalia,
you are not a party.
doesn't matter. This court has also requested Sri A. Chalia, learned Standing Council Finance Department, to coordinate with Sri Goswami in getting the instructions. You give him a copy.
Lordship, I'll.
Let the name of Sri Chalia, let the name of SC Finance be reflected in the cause list. This you can take it back, or do you have extra copies?
We have extra copies. If you.
Item 5.
We have the loss specific matter relating to promotion of the petitioner to the post of commissioner state from ACS cadre. So as per affidavit filed by the Aston number 3, her name was commended, but not promoted. The WBT department not yet filed the affidavit.
My lord, there is a problem, my lord, with WPTPC. As of today, from 2022, this department doesn't exist, my lord. Now, this says he belongs to, my lord, OBC,
Yes,
SC, my lord. So now this is under social justice and empowerment, my lord. Unless, my lord, my friend,
Who appears for social justice and empowerment?
RM Das, my lord, and social justice is not a party here, my lord.
at that time the WBT is the party that
From 2022, my lord, that has been abolished, that department. So
But the decision is taken by which department? At that time or presently?
now it is social justice and
No,
empowerment.
that we have understood. But the direction or the decision should have been taken at that point of time.
yes, sir, at that
WPT and BC, my lord.
So Gogo, I think you make the social welfare. It is not difficult.
Social justice and empowerment.
Empowerment. And since you have a standing council,
Yes, my RM Das.
you file a formal application, will allow, and we'll ask Mr. Das to have the instructions. Okay. Third, Sri N.G. Gogoi, learned counsel for the petition. Full stop. Para. Sri R. Dhar, learned state counsel, has however informed that the WPT and BC department has been
Has been
abolished,
Tripartite.
has been,
Think that-
do you use trifurcate?
My lord, 3 departments, my
No,
lord.
no,
So,
do you use the expression
my
trifurcate?
lord, my lord, honorable court has already in judicial order has
Trifurcate.
trifurcated, my lord. That 3 departments has come out of
No,
one
that we have
department.
understood.
Uh,
Bifurcate is that
Trifurcated,
trifurcate.
my lord, but
If
it
there
has
are 4 departments, then
my
what do you
lord,
say?
welfare of Borderland,
If there are 4 departments, what expression will you have?
my lord,
5 department, bifurcate.
my lord.
I don't think. Has been divided into 3 departments.
departments.
Let us be very simple and clear. 3 departments, and the concerned department
Is
is the newly formed
social justice and
Social
empowerment.
Justice and Empowerment Department, which has a standing council also. What's the para? Sri Gogoi, Learned Council accordingly praised for filing an appropriate application for implement of the concerned department, for which 2 weeks' time is allowed.
Highly object.
Along with the IA, you also serve a copy of the writ petition to Mr. So things will get faster.
Highly object. Item 6.
May I please, Lord, I'm appearing for the read petitioner and I may be allowed to withdraw my case.
You got the relief.
Philip, my Lord, they have already settled the matter. As
Okay. Your
as per the
AK Jain,
instruction received.
AK Jain,
Occasion, ma'am.
Sri AK Jain Learned Council. I heard Sri AK Jain Learned Council for the petitioner. Whereas, yes, Finance Department, Mr. Chalia, that's Government Council, Madam. Also heard MSM Bhattacharya, Learned State Council,
805.
and Sri A. Chaliha, Learned Standing Council, Finance Department, para. Sri Jain, the Learned Council for the petitioner submits that during the pendency of this writ petition, comma, the matter has been settled, and therefore he would not like to press this petition anymore. Full stop, para. Writ petition accordingly stands dismissed as not pressed.
Right. Okay.
7.
My lord, in this case, we have filed an IA for impeachment of Punjab National Bank. My lord, what
Okay.
happened?
Yes. Amalgamation. Now,
Amalgamation.
okay, we'll allow this, madam. You will appear for Punjab National Bank?
Yes.
Okay. Heard Sri S. Chakraborty, Learned Counsel, for the applicant petitioner, who by means of this application has prayed for implement of the Punjab National Bank and its officials in the connected WPC 8428 of 2018. Full stop. It is submitted that though the initial dispute was against the United Bank of India and its officers, comma, the said bank has merged with the Punjab National Bank, and therefore there is requirement to implement the Punjab National Bank and its officers. Full stop. Para. M. Musari, Ms. S. Musari, Learned Counsel, is present for the respondent bank and does not object to the same. Full stop, para. Taking into consideration the facts and circumstances, comma, the instant application is allowed, and
Respondent number 6, 7, and 8 of
and
this IA.
the allowed by adding allowed by adding the Punjab National Bank and its officers as the
Respondent number 6 to 9.
Mr. Chakraborty, have not see the how have you made the parties? 6 is okay. Punjab National Bank, C7
Managing Director.
and CEO what? 8, nothing. 9, nothing.
Managing as CEO that Punjab National Bank.
Not there.
Typography. May be allowed to, or in fact, only Punjab National Bank may also be.
It depends up to you. We can file a fresh IA. Nowadays, we cannot even allow you to correct by hand. Otherwise, you'd have corrected. These are minor mistakes.
Just kept my sorry.
You file a fresh application. You withdraw this. Huh?
Hello, the
Oh.
problem is this man is 86 years old and he is not in his station, is undergoing treatment at Katama. In that case, my lord, lordship may permit me to implead Punjab National Bank only.
Okay, then I think my purpose will be served.
Sir, it will be served, my lord.
क्या लास्ट में क्या बोला? By adding the Punjab National Bank as the respondent number 6, full stop. The officers who are said to be, the rest of the other respondents who are sought to be implemented do said to be officials of Punjab National Bank have not been properly described, and therefore the implement is restricted to Punjab National Bank. Full stop. Sri Chakraborty, the learned counsel, has also submitted that implement of Punjab National Bank as the party respondent, as the main party respondent, would serve the purpose. Full stop. Para. I accordingly stands allowed. Full stop. Para. In the main WPCU, right? In view of the order passed today, that is 2/4/2024, whereby I number so and so has been allowed, impleading the Punjab National Bank, impleading नीचे लिखा पूरा address, so and so, I may be addressed as the respondent number 6, Sri S. Chakraborty, learned counsel for the petitioner, is directed to file amended cost title within a period of a week from today. Writ petition is of 18.
18.
Let the writ petition, so since the newly implemented respondent number 6 is already represented by, will be there by Sri S. Dutta, learned senior counsel, assisted by Sri and Miss S. Musari, learned counsel, fresh notices is not required to be, and no formal notice is required to be issued.
Okay.
Full stop. List this case for hearing,
No, my lord, admission.
admission hearing after 3 weeks.
Can
But
I-
admission hearing will go for final disposal, 18
Yes.
matter.
So, my lord, can I have a fixed date? In that case, it will be easier.
After 3 weeks, first you file this amended thing, okay? 9 to 11. Very good, Silna, too. You had mentioned this matter. You had mentioned.
Lordship, on last occasion also, they have taken adjournment of Lordship on 10/11/23. And presently, Lordship, the prosecution sanction has been accorded against the petitioner, Lordship.
Is there any stay order?
Yes, Lordship, earlier, and there, as there is stay operating Lordship, so they are enjoying the benefit of the interference of the
Well,
Honorable
praying
Court,
for
Lord.
adjournment.
Some past difficulties and we are engaging some.
Then, Lordship,
We'll fix
before,
the date
yes, Lordship,
My
as
lord,
soon
cannot
as
be
possible,
fixed after-
Lordship, otherwise,
after Bihu, man.
after Bihu, matter of which year? 21. We'll have a fixed date, madam.
because
We'll give a
otherwise,
fixed date. Well, no further adjournment.
then immediately after the
Yes.
reopening, Lordship.
Okay. What is
Because
your name?
already in January, Lordship, so
Okay.
they are aware of these things, Lordship,
What is your name?
present update.
And P. Prakash Bora.
P. Bora. Sri P. Bora, learned counsel, has submitted that Sri N.J. Khatunier, learned counsel for the petitioner, is having some personal difficulty and accordingly prays for an adjournment. First up, para. Miss M. Bhattacharya, learned state counsel, however, informs that even on earlier occasions, adjournments were sought for, and since there is an interim order operating, in spite of grant of prosecution sanction, the matter has not proceeded. Full stop, para. Considering the above, while adjournment is granted, the matter is directed to be listed for admission hearing on 22/4.
Lordship. And Lordship, no further adjournment,
Um,
Lordship.
this, the, any prayer for further adjournment may not be considered by this court. Hello, is there a requirement to extend the interim order? Madam, is it limited by time?
It is already state, Lordship, the departmental inquiry, Lordship. This has been state, Lord.
Is it limited by time? No.
It's not limited by, because the earlier court has granted that there is no bar, they can proceed, Lordship, but uncertain. But after the, in 2019, Lordship, prosecution sanction was passed. And then again, Lordship, the Honorable Court has passed an order of staying the order, Lordship. I have this one.
Interim order,
Petition connection with the interim order, then 6520, Lordship. That's an into the.
there is nothing like that.
Operation of the order dated 31/8, Lordship, the earlier prosecution sanction, Lordship. They
Not
have challenged.
required, because in earlier orders, there is no mention about extension of the interim.
Extension, Lordship. That's why, Lordship, fresh prosecution sanction has been accorded, Lordship.
एगो कुछ बोलना जरूरी नहीं.
Deeply obliged.
itu ulta ulta actually. I had to report also. 12, Mr. Das, yes,
Earlier 2 times rejected, Lord.
they are not appearing. Why?
On earlier occasion also, the non-appearance is there, Lord.
Who is appearing? Names. None appears for the petitioner on call, whereas Sri K.K. Das, learned additional PP, Assam is present. Full stop. The para, even on the last 2 occasions, that is 5/3/2024 and 15/3/2024, none had appeared for the petitioner. Full stop. You have
It is not. On a, not called for actually.
para Sri K.K. Das, learned additional PP, has informed his court that the prayer of the petitioner for bail was rejected by this court earlier
Okay.
on 2 occasions, and no new grounds have been made out. Full stop. Para. In the interest of justice, a final opportunity is granted to the petitioner to make representation. Full stop. Para. List this case on 4th, day after tomorrow. Full stop. It is however made clear that in case of further non-appearance, this court will proceed with the matter and pass appropriate orders.
Item 13.
Yes, what is this matter? Contempt of 2018.
That's all. That's appointment.
Referential appointment.
Sir.
Which is the order which has been which is alleged to have been violated? You have filed your affidavit.
That's why I have filed a, for respondent number 1 and 3. They are no longer
And madam, you are for whom?
respondent number 6.
Filed affidavit. You have filed affidavit. Affidavit filed. File affidavit? No. Why haven't you filed affidavit? What are your explanations? Where is the order? Are they interested or not? D.K. Sharma, A. Talukdar.
Annexer A. Left 6. Consider this.
Did you consider or not? During your tenure.
Already passed.
Hmm?
Order had already passed.
Okay, you had considered and passed speaking order. Let us have a look. Please give a copy. Not. Where? Which page?
But last page,
Okay.
Annexer 1.
Okay.
Page. That's it. This honorable court has in other case topics set some guidelines topics for appointment of this kind of appointment topic. And
No, madam. As per the speaking order of 4th of October 2018. Okay, do you have a copy of 4th of October which you just placed before this court? Last paragraph, order, the matter, no decision was taken. It was sent to the Deputy Commissioner Kokrajhar to take a decision. Who is appearing for the Deputy Commissioner Kokrajhar?
are there for Niranta
Barua,
Porwa, I have
you
appeared
appeared.
also.
What is the stand of Niranjan Barua? Now, after this speaking order
That's it.
of 4th of October 2018,
That's it. Niranjan Porwa has transferred 11,018 lots. Thereafter, some other person has
yes, Bornali Deka was, who's appearing for Bornali Deka? You appear. What is your stand, madam?
I am known as DC of Kokrajhar.
That we
My
know.
name may be Straikov.
That we know, madam, but during a particular time, you were the Deputy Commissioner of Kokrajhar. What action did you take after the speaking order? Where is your affidavit? Have you filed affidavit or not?
I don't.
Why are you appearing like this? If you don't even know whether you have filed affidavit. These are contempt matters, not matters of joke. Ms. Bora, see, if the speaking order was for consideration, and you take an order which is adverse to the petitioner, we would have still closed, giving liberty to the petitioner to challenge that. But this speaking order is not a consideration. It has simply remanded the matter to the Deputy Commissioner of Kokrajhar, who at that point of time was on Niranjan Barua, whom you represent. You say that immediately after passing of the order, Niranjan Barua
That-
was transferred, or he had no longer in the post. Then one Bernali Deka had come, response number 6, newly implemented. She's been represented. But what Bernali Deka had done?
If I had to. That.
She doesn't even know whether affidavit is filed or not. This is not expected.
Uh,
Madam, you are appearing for whom? Who is for? Debajyoti Datta. You don't have much role. After the Assam Accord Department has remanded the matter to the Deputy Commissioner Kokrajhar, order needs to be passed by Deputy Commissioner Kokrajhar. And Madam Boro, we are for whom? Which respondent? Your role is also very limited. We want the follow-up action after the 4th of October 2018. Simple as that. Yes, what is your name, madam?
Jyotsna Das, appearing on behalf of
Ma-
KJ Hazarika.
Madam Das, do you have a copy of this 4th October order 2018? Ms. Bora, just pass it on to her.
I would pass it.
You don't have 4th October. You just passed to the 4th October speaking order copy. You have not even filed affidavit.
Lordship, they have not filed any affidavit.
No affidavit filed. Who is your senior?
AJ Hazarika,
Where is he?
out of state.
You had entered
And-
appearance in 2022 and you have not even bothered to file affidavit.
But they adjourned this matter from this itself.
18 matter. Do you think that your prayer for adjournment would be granted without even looking into the things? Yes. See, the order was for consideration. The department had remanded the matter to the Deputy Commissioner Kokrajhar, and a final order was to be passed by the Deputy Commissioner Kokrajhar and put it on record. Whether you actually appoint him or not, that's different. Where is the consideration? And what follow-up action did you take? Whether it was actually... Mr. Sharma, your case, will you appear? Contempt matter.
Item 13, my lord.
Yes.
My lord, my junior MSA Talukar is looking after the case. He speak today, my lord. And perhaps-
We were wondering whether
Well, I
you
could
appear.
not appear at this.
That is okay.
Lordship may kindly.
No, but some affidavits are yet to come. 2018 matter affidavits not filed. This is not done. Matter has to be brought to a logical conclusion. Thereafter, you can challenge the speaking order. Speaking order is not yet passed. One speaking order has simply remanded the matter to Kokrajhar.
I am handicapped, my lord, because I could not appear.
Day after tomorrow. Or Friday. Friday. We would have otherwise closed this matter if
Right.
the order is passed, giving you liberty to challenge. There is no order. A prayer for adjournment has been made on behalf of the petitioner. Full stop. It appears that the order in respect of which non-compliance has been alleged was with regard to considering the case of the petitioner for appointment in terms of the Assam Public Service within bracket preferential appointments bracket close rules 1999 within a period of 4 months. Full stop. As per the version as spelled out in the affidavit filed by respondent number 1, comma, a speaking order, a so-called speaking order was passed on 4/10/2018, whereby the matter was simply remanded to the Deputy Commissioner Kokrajhar. Full stop. The then Deputy Commissioner Kokrajhar, Sri Niranjan Borua, in his affidavit, has, however, submitted that immediately after passing of the aforesaid order, comma, in November 2018, comma, he was transferred. And thereafter, it appears that the successor incumbent in the post of Deputy Commissioner Kokrajhar was implemented as respondent number 6. Full stop. Though the said respondent number 6 has appeared, is represented by a counsel, comma, till date, neither any affidavit has been filed nor any orders passed pursuant to the order dated 4/10/2018 has been placed on record. Full stop. Such omission of the commission of an incumbent in a matter where contempt has been alleged cannot be taken lightly. Full stop. In the interest of justice, full stop, para. Ms. Jadas, learned counsel for the respondent number 6, however, submits that her senior has some personal difficulties today and prays for an adjournment. Full stop, para. Considering the aforesaid prayer and also the fact that the petition is pending since the year 2018, a small adjournment is granted, directing listing of this matter on 5/4/2024. 5/4, no, 8/4. We give some more time. 8/4. 8/4. Mr. Nath? See, fours, we are not too much concerned with 4, 5, 1, 2, 3. See, 1 at that time has said that we have remanded, we have passed a speaking order, but that is not a speaking order. It is only remanding to the Kokrajhar DC, who is the competent authority. DC needs to take a call, pass an order, either accepting or rejecting. That we have read the affidavit, that we are not impressed at all. You have not filed any review, neither any appeal. Where is the consideration? No, where is the consideration? No, where have you said? Then why did you pass the order of 18th, this 410? 410 is your order. It was remanded to the Deputy Commissioner Kokrajhar. See, we cannot go into the legality, validity of the order passed by this court unless the order is put to challenge or there is a prayer for review. We will not go beyond the order. We want the implementation of the order. You can say you have considered not permitted, we considered permitted. That's up to you. That is a different aspect. Yes, consideration. Yes. 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 We will not see 1999. No, why should you open up this? We are not on appellate court. Neither this is an application for review. Correctness of this order, you cannot even raise this question. Whether if you think this order is incorrect, file a review. No, what about this order of 4th of October 2018? Where is the principles of estoppel? It will go for a toss. See the order passed by your department, the principal secretary. See the last line. In view of the above, Deputy Commissioner being an appointing authority is to take up the matter in accordance with the so-and-so rules in light of this and repealing the same consultation. Deputy Commissioner needs to pass an order, that's all. If Deputy Commissioner considered the facts and said that you are not eligible, that's all. That legality, validity, the petitioner can challenge in a separate proceedings.
But I would like to, but the 99 consideration under that 99 rule will come. In his selection process, he has to offer his candidate and he has to apply.
Where is the communication that we cannot consider because of this?
But that is the procedure and this is in the rule.
No, where is the
99.
communication to the petitioner? Where will this order go of the court? And that too after passing of 410. Why did you pass 410? Your department has passed 410. Have you seen the order of 410?
Yes, sir.
See the last line.
I have seen.
Deputy Commissioner needs to take up the matter, pass an order, and the matter.
But the petitioner, whenever offers a candidature, stating that I am claiming benefit under this act, then this candidature has to be given preference.
Sir, Nath, where is the consequential order after 410/2008?
No, deputy commissioner has to.
Deputy Commissioner has
if,
to.
If no process has been, the petitioner has to apply in that process. Then only he can be considered. Otherwise, without any selection
See,
process, he cannot.
we are not buying this from you. We will not buy this. You have already filed your affidavit.
True.
You have given not only the affidavit, you have given a copy of the so-called speaking order, which is not a speaking order at all. You have simply remanded. Now you are out.
Look.
We need the Deputy Commissioner's version. That he has not applied, that is okay. The Deputy Commissioner says nothing.
Look.
The earlier
You see-
Deputy Commissioner, maybe rightly so, he said
see-
that immediately on the passing of the order, I was transferred. Okay, no problem.
You see-
New Deputy Commissioner implemented.
Yes.
Why she should say that there is no application, cannot be considered. Monday. And madam, come prepared. Your client seems to be taking matters very lightly. Advise your client properly. Otherwise, you know how to deal. Yes.
May please go to. The petitioner is the lady constable of CS,
Okay.
and she was appointed in the year
Okay.
2008, on 28 to 2008.
Ms. Gayan, you'll be appearing?
Yes.
Thereafter, my lord,
Just a minute. Nine, 5, 3, 2. Yes, you are a lady constable.
lady constable of CIS, Central Industrial Security.
Hmm.
I was initially appointed on 28 2008,
20,
20 August
20,
20
8, 2008,
2000
appointed
appointed
as constable.
constable.
Hmm.
And after training, my lord, I was posted at Kota, Rajasthan on 16/4/2009.
16/4/18,
2009.
9. Posted
Post.
at Kota.
And thereafter, I was transferred to Dibrugarh Airport
When?
on 14/9/2012.
14/9/2012, transferred to Dibrugarh.
Yep.
Okay.
And I was on leave, my from 11/9/2012,
11/9/2012 to
extended up to 8/11/2012.
8/11/12
2012
on leave.
on leave.
While you were on leave, the transfer order was passed.
My lord, initially, my
You
lord,
said you went on leave on 11/9.
Aye.
Transfer order is of 14/9.
14.
Okay.
My lord, what happened? I could not join in service thereafter
At Dibrugarh.
at Dibrugarh. And due to my overstay, my lord, there was a departmental process penalty was imposed, my lord, reducing increment,
Penalty of
Penalty.
what?
reduction of payment,
Okay. Reduction of pay.
payment
And anything
for
else?
3 years. For 3 years.
That was the only penalty.
That was the.
Okay.
During this time, my lord, I was suffering from ill health. My lord,
You have challenged this penalty. That is the subject
no, my,
matter.
no, my,
Okay.
that was not the case. During this period, my lord, some domestic problem was there, my lord. That is why I could not join, my lord.
Hmm.
And ultimately, I
submitted my resignation to the authority on 28/5/2013.
28/5,
2013.
2013.
Right.
Okay,
And that was provisionally accepted on 29/5/2013.
okay,
And my lord, on the same day, I had another letter, my lord, I was discharged
29/5.
29/5/2013 and struck off from the role with effect from the next day, that is with effect from 30 May 2013.
Okay,
Then, my lord, on 1 November 2013, 1st November 2013, my lord, I submitted an application for withdrawal of resignation,
after his acceptance.
my lord. And that was rejected, my lord. On the, mainly on the ground that it was required to be submitted within 90 days. And there was a delay of 65 days in submitting the application. Thereafter, the petitioner.
When was it rejected?
My lord. My lord, letter dated 29/11/2013 by the commanding officer.
Okay, then,
Thereafter, I also submitted another representation before Director General
hmm,
on 11/7/2014. And that was also rejected by the letter dated 22nd/7/2014.
okay,
Thereafter, several representations were also filed before the ministry matter that was also rejected on the same ground. And now, my lord, thereafter, the petitioner filed a writ petition before the Honorable High Court of Jharkhand, since she was a resident of Jharkhand, my lord. And that was rejected, my lord, on the ground of having no jurisdiction, territorial jurisdiction, my lord. And liberty was given to approach this honorable. That was ordered dated 14 February 2019.
page,
Page, my lord, 47, my lord.
WPC,
WPC number, my lord, WPS number, my lord, 3219 of 2018.
3219 of
2018.
2000, Jharkhand High Court.
Jharkhand. And that was dismissed on 14 February 2019,
Hmm,
giving liberty to approach this honorable.
yes,
And accordingly, this petition was filed.
okay,
Now, my lord, in this matter, mainly two issues are involved. And we are challenging the acceptance on the ground that it was not proper matter. It was a hasty acceptance matter. That was one of the issue. And second issue was that, my lord, my application for withdrawal of resignation has
yes,
been rejected mainly on the ground of delay on the basis of office memorandum dated 4 December 2007. That is annexure M page 50. That was issued by Department of Personnel and Training.
yes,
And there is a provision for exemption and for relaxation of delay, my lord. And my humble submission is that my application is required to be considered under that provision.
there is a provision for not for exemption, condemnation.
Condemned.
That was not adhered to.
My, that is one of my subjects. Now, my lord, regarding first issue, that, my lord, acceptance is not proper. Rule 58, my lord, of the CISF rules, my lord, we have quoted in paragraph 23, case 9, my lord.
Yes.
Paragraph 20. That is the rule, my lord. 58, resignation. The appointing authority may, during the period of probation or thereafter, permit any member of the board to resign from his post with effect from such date as may be specified in the order accepting his resignation, provided that before acceptance of resignation of any such member of the board up to the period of 10 years from the date of appointment in the board for reasons other than accepting a job elsewhere or which either clearance has been given shall be required to refund the cost of training imparted to him in the force or a sum equal to 3 months' pay and allowances, whichever is more.
Hmm.
The resignation of a member of the force which is under trial or
Not-
whose
not-
conduct is under
This is not
inquiry-
applicable to you.
My lord,
2 is not applicable to you.
two is not
Even
applicable.
proviso is not applicable.
No, not.
Only the first part.
First part, my lord, that is also where some conditions were imposed in the provisional acceptance, my lord, and that has been cleared. Here is one of the condition was to refund the 3 months, my lord, training. That was complied. So, my lord, next rule is paragraph 25, rule 59, discharge certificate. Whenever a member of the board ceases to be such member for any reason whatsoever, a discharge certificate in the form specified in Appendix D annexed to these rules shall be given to him.
Hmm.
That has not been complied. Discharge certificate was
Okay.
we are taking result of rule 77 of the same rules, my lord. That is quoted at paragraph 28, my lord, page 11.
Hmm.
Other conditions of service,
77.
77, rule 77, page 11. The members of the board shall, in respect of all matters regarding conditions of service for which no provision or insufficient provisions have been made in these rules, be governed by the rules and orders for the time being applicable to officers holding corresponding posts in the central government in respect of such. My humble submission before your lordship is that the provision made in the CSF rules 2001, that is, my lord, rule 58, is not sufficient. So, corresponding rule of CRPF rules, my lord, that is applicable for the procedure of acceptance of a resignation. And relevant provisions of CRPF rules I have quoted in paragraph 30, page
Okay.
13,
Page,
13.
which rules?
CRPF rules 1955.
Oh, no. CRPF rules. 1930?
1955, ma'am.
That's a nice CRPF. That is-
Act is CRPF Act 1949 and
Okay.
rule is CRPF
Okay.
rules.
Which rule?
CRPF rules 1955, ma'am.
Rule?
CRPF rules
Rule what?
1955.
That not,
Oh, my lord, 17, rule 7.
70.
717.
Rule 17.
7.
Okay.
Subject to the provisions of the schedule appended to the act, any member of the force shall at any time before he has completed 3 months service or after the completion of full period of service for which he is engaged, be entitled to claim his discharge from the force by applying to his appointing authority through proper.
Where are you reading?
My lord, page 13, my lord, paragraph 30,
Rule
rule, my lord, 17, my lord, discharge.
17. Just a minute, please. Discharge. Yes.
Subject to the provisions of the schedule appended to the act, any member of the force shall at any time before he has completed 3 months service or after the completion of full period of service for which he is engaged, be entitled to claim his discharge from the force by applying to his appointing authority to the property. Now, my lord, section 6 of CRP Act 1949, that is relevant, my lord.
Section 6.
Section 6 of Act 1914. Resignation and withdrawal from the
Section 6.
no member of the force shall be at liberty to resign his appointment during the term of his engagement, except before the expiration of the first 3 months of his service, or withdraw himself from all or any of the duties of his appointment without the previous permission in writing of the commandant or assistant commandant or any other officer authorized by the commandant to grant such terms.
See, Mr. Das, in 6, there are two different facets. Number 1 is resignation, and number 2, the expression is end. It's not or. Resignation and withdrawal from the force. So what you are trying to harp would at best be applicable for 6A, not for B. It's not a withdrawal. It's a resignation. How do you resign? Resign appointment during the term of his engagement, except before the expiration of first 3 months of his service. No member of the force shall be at liberty to resign his appointment during the term of his engagement, except before expiry of, that means resignation under the CRPF rules is not contemplated except during the first 3 months. And the second part is regarding withdrawal. They have not used the expression resignation. You can withdraw, but with the previous sanction of the appointing authority.
Now, my lord, I would like to bring to the notice of this honorable court the schedule of the Act, my lord, CRPF Act 1914. Is 10 of my
page.
Schedule of my lord. Act. Schedule of the Act, my lord.
Okay.
CRPF Act
Okay. Yes, yes. Which schedule?
Only one schedule.
Yes.
Recruiting rule. After you have served in the force for such period as the central government may prescribe, you may at any time, when not on active duty, apply for discharge to the officer to whom you may be subordinate to the commandant, and you will be granted your discharge after 2 months from the date of your application, unless your discharge would cause the vacancies in the force to exceed 1/10 of the sanctioned strength, in which case you shall be bound to remain until this objection is or removed. But when on active duty, you shall have no claim to a discharge, and you shall be bound to remain to do your duty until the necessity for retaining you in the force ceases, when you may make your application to the above-mentioned manner. Provided that if you wish to withdraw from the force you may submit your resignation at any time before the expiration of first 3 months of your service, but not afterward until the completion of the period prescribed as aforesaid. The commandant may either accept your resignation forthwith or at the end of 3 months from the date of its receipt. Provided also that the commandant may, if he thinks fit, allow you to resign at any time on your giving 3 months notice of your wish. That is the relevant provision, my lord. And my lord, here was a guideline of the CRPF, my lord, that was issued by the Director General. That is 17th May 1990. I have quoted in page 14 of my report. Page
Read.
14 of
Yes.
my petition.
Yes.
In the bottom, my lord, the CRPF guideline on discharge. Subject acceptance and withdrawn of resignation. In this context, the instructions regarding the procedure to be followed in accepting the resignation and withdrawal of resignation as contained in DRT's office memorandum number so and so dated 11/2/88, published in CRPF Gazette in the month of May 1988, should be clearly understood and explained to the member. It is imperative that the authority competent to accept the resignation should therefore personally explain the growing unemployment problems and consequences of discharge to the persons seeking discharge from service, while it is not in the interest of government to retain an unwilling government servant in service. A care has to be taken that no one is allowed to proceed on discharge, voluntary return, without any compelling reason. As a model employer, the administration must conduct itself with high probity and conduct with its employees and should always be careful enough to listen to their problems. The authority competent to accept the resignation should therefore ensure personally that the person seeking discharge, voluntary retirement has genuine and compelling reasons. To ensure it, the authority concerned should obtain an undertaking from the individual to the effect that he has been explained in detail about the likely hardship which he may face in this uncertain and difficult economic age after his discharge, voluntary retirement. Such an undertaking should be kept on. That is the guideline. So, my lord, if we go by the rule 77 of the CISF rules, since there is no sufficient provision in the rules or guidelines for acceptance of, my lord, resignation, these corresponding provisions of CRPF Act rules and guidelines, my lord, that is applicable to the CISF. That is my. And in my case, my lord, I submitted my resignation on 28 May 2013. And on the next day, provisional, my lord, acceptance was issued. And on the very day, my lord, I was discharged from the service. So it was a hasty acceptance. And I did not get opportunity of reflection. And it is my case that, my lord, that I was having a domestic problem at that time, due to which under compelling situation I could not join even after expiry of my leave. And ultimately, under compulsion, I have, my lord, resigned from service. But I could not, my lord, save my marital life. And ultimately, I had to leave my matrimonial home. Then, my lord, I felt that I have done a mistake. And during that period, my lord, my health was also not, health condition was not good, my lord. although in the, my lord, in the writ petition submitted before the Jharkhand, my lord, High Court, all medical documents were submitted, but not submitted along with the writ petition. I have submitted here in my reply in affidavit that I was in my lord, under medical treatment, my lord, during that period. So, my lord, my resignation has been accepted on 25/2013, and I was discharged with effect from 30 May 2013. And my application for withdrawal of resignation that was submitted on 1st November 2013. So there was a delay of, my lord, 65 days beyond 90 days. Now, my lord, your lordship may kindly look into the office, my lord, office memorandum on the basis of which my application for withdrawal of resignation has been rejected. That is case 51 of my report.
Yes.
Referring of cases of withdrawal of resignation by Ministry Department guidelines. The undersigned is directed to draw the attention of the Ministry Department's administrative authorities to Rule 26 of CCS Rule 1972, wherein it is provided that resignation from service of a post, unless it is allowed to be withdrawn in public interest by appointing authority and officer of past service. Sub-rule 4 of this rule provides the conditions under which the appointing authority may permit a person to withdraw his resignation in the public interest. One of the conditions is that the period of absence from duty between the date on which resignation became effective and the date on which the person is allowed to resume duty as a result of permission to withdraw the resignation is not more than 90 days. The purpose of the aforesaid provision is that once a person has been relieved of his appointment on acceptance of his resignation letter, his relation in the post with the government gets terminated. An exceptional provision to consider or request the withdrawal of the resignation was made in view of the possibility that the circumstances under which the individual resigns from the post materially change soon after his resignation, thus making the purpose of his resignation interrupt. The time limit of 90 days between the date on which the resignation became effective and the date on which he is allowed to resume duties after withdrawal of his resignation is very sacrosanct to scheme of acceptance of withdrawal of resignation by the government. Of late, this department has been receiving proposal from ministries departments seeking relaxation in the above time limit by invoking Rule 88 of CCS rule. In most of such cases, it was found that not only had the individual not given his application for withdrawal soon after the acceptance of resignation, but also did not have convincing reasons for the same. The administrative departments have also been forwarding such requests to his department in a routine manner. The matter has been reviewed in this department and it has been decided that it is only in exceptional cases which are properly justified from the point of public interest by the administrative department concerned, would this department entertain any request to relax the above time limit of 90 days. Even in such exceptional cases, proposals would be considered only if the time limit is exceeded, only very marginally. The ministries departments are therefore advised to avoid sending such proposal to this department for relaxation under Rule 88 of as far as possible. Now, under condition 3, my full submission before your lordship is that this condition is applicable to my case also. And my delay, that is of 65 days, is marginal one. And that can be considered.
What is Rule 88 of the CCS pension rules? CCS rules. Or to relax.
My lord. I have put it, my lord, the Rule 26 of CCS pension rule 1972. That was also relied on by this my lord, office memorandum. I have put it in page 12, my lord, that draft.
Okay. Yes, anything else?
My lord, from number 1 to 6 has filed their my lord counter affidavit. And in paragraph 2, my lord, they have stated the main grounds of their rejection. That is the case 3 of their matter counter affidavit.
Yes. Paragraph?
Paragraph 2, my
Hmm.
internal test.
Hmm.
It is pertinent to mention here that as per Government of India Ministry of Personnel, PT and Pensions Department, Office Memorandum number so and so dated 4/12/2007, that is an except. Once a person has been relieved of his appointment on acceptance of his resignation letter, his relation to the post with the government gets terminated. An exceptional provision to consider a request for withdrawal of the resignation was made in view of the possibility that the circumstances under which the individual resigned from the post materially stands soon after his her resignation, thus making the purpose of his her resignation stuck. The time limit of 90 days between the date on which the resignation becomes effective and the date on
That
which
is our application of the office memorandum.
my lord,
Yeah.
at the bottom, my lord,
Same
mainly
exception.
3 grounds have been my lord mentioned.
Yes.
her re-employment in service was not considered by the responding authorities because of the time period of tendering application for re-employment in service was beyond 90 days. Two, her application for re-employment in service was not in exceptional nature.
Hmm.
And the same was not justified from the point of public. These were the main grounds of their decision.
Okay. Okay.
It was,
Any case law you'd like to
my lord,
rely upon?
my lord.
Any case law you'd
No,
like?
my lord, there is no proper case, my lord. I have gone through several cases, but I have not found
Okay, yes,
suitable.
Madam Gan?
Yes, we did filed that litigation matter, that is case number 21 of my litigation.
Just a minute. Yes, what do you say?
My lord, yes, we did file that litigation matter. On
Page?
case 21 of my activity. Matter.
Page 21. Okay. This is the application for resignation.
Yes,
Date,
application for resignation, but
Date,
that is not there, but 29/5 matter. That is not there, but.
doesn't matter, 29/5, 2000?
2013.
Yeah, okay.
Well, here the contention of the petitioner is that I, Lady Constable Sri Nitu Kumari Pandey, submitted that I am suffering from family problem. First 3-year-old daughter, look after mother-in-law, father-in-law, myself pregnant for 7 months and physically and mentally sick. My husband is serving in Uttar Pradesh government. That are the contention in the resignation matter. Immediately after that matter, page number page number 28 of the writ petition.
28.
28. Such a resignation from service of the writ petition.
Your acceptance.
Yes, that is acceptance matter. Refers to the letter so and so. The resignation from the service in respect to so and so, it has been provisionally accepted by the competent authority with effect from 29/5/2020, subject to the following conditions. There are some conditions, my lord. She had to clear all the government and non-government dues, if any outstanding against him. She has to be free from disciplinary vigilance angle. She has to deposit her identity card. She has to refund cost of IT training search or the 3 months pay on allowance. She will deposit government clothing and equipment as per instruction issued in his disregard. And that has been issued to also to the deputy petitioner, my lord. After this acceptance, my lord, that page number 30.
30.
Yes.
Same day,
Same
29.
29.
Earlier was the 29.
29. And there is also 29. Same day, my lord.
Okay. Page 29, page 30.
Yes, 30. My lord,
Yes.
application is dated 28/5. Here it is referred 28/5.
Yes, yes.
My lord, in page number 30, my lord, reference your application dated 28/5/2030.
Yes.
The resignation from service tendered by you have been provisionally accepted by the company. Accordingly, we will relieve from the unit on 29/5 to the subject to clearance of the from the DE vigilance angle and clearance of all government dues, if any, by you the following aspect. But that means he had accepted at that point of time, my lord. He never complained on that, my lord. After that, my lord, page number 33, my lord.
Yes.
32 is my lord.
Type copy.
Yes. 33 is the, and 32 is the
Type copy.
type
Yes.
copy file. The resignation from service tendered by so and so Dibrugarh under the energy control agency Guwahati is accepted by the competent authority with effect from 29/5 to as per rule 58 of the CISF. Accordingly, no acre number so and so need to go relief from the CISF ASC Dibrugarh Airport on 29/5 on resignation from service Sakop strength of this unit as well as the Central Industrial Force with effect from 30/5/2013. And that has also been issued to the person concerned also. That is the distribution number 1 file. On that day, she has been informed.
Okay.
After that, she was kept silent, my lord. On 1/11, she filed his representation for re-engagement in the force, my lord.
111,
1/11, my lord.
13.
Yes, 2013. That is
For withdrawal.
for withdrawal of his resignation.
Her.
Sorry, her resignation.
Okay.
As per office memorandum, that is 90 days period, but he had already extended the 90 days period required to file the resignation, withdrawal of the resignation. But she filed that on 1/11 after expiry of 1/11/2013, and that I think he did not annex that copy of his copy of his withdrawal of the resignation, application for withdrawal of the resignation. And there also he never explained about his illness, about her illness.
Where?
My lord, that is not annexed by him.
Do you have a copy?
I have a copy. That is in.
You have not annexed in the petition, your affidavit.
I have got a.
Okay, doesn't matter. Doesn't matter.
But that's her.
Okay, what has been
My
stated?
lord, that is in Hindi. May Mahila.
No, what has been stated? Just tell
That
it.
is nothing, my lord. At that point of the time, I had some difficulty. Now I don't have any difficulty. That is only the application of declines. And there is no explanation of his heart illness and anything, my lord. But
Okay.
and now he has filed one affidavit in reply, mother, where he stated that due to illness, not filed this application. That is page 96 of this affidavit, that is page 96 of running case.
Reply affidavit.
Reply affidavit, running case 96.
In the writ petition?
In the petition, mother, there is nothing on that. Now only they have brought, they have brought.
Okay.
29/5 from 29/5 to 1/11, that is beyond 90 days, my lord. And Honorable Court goes for his medical document that is beyond his 90 days period. His illness is beyond the 90 days period.
Where?
That is page number 103, my lord.
103.
From 26/8/20, 10,030. That is certificate, medical ticket. It's not nothing other till 1/11/2000. That in her application, he stated that due to some due to some problem, kind of domestic problem, she resigned from the duties. But now she don't have any domestic. She required his service for to look after his family matter. That is only the ground of his. That is not a sufficient ground as per mentioned in the office memorandum. Office memorandum dated 4/12/2000. And next is the next point is that my lord, that was
Just a minute, please. Okay, yes.
the rejection was of 2/12/2013 matter. Rejection of re-employment. 2/12/2013.
Page?
Page number 37 of the PPT. And my lord, she approached the honorable court only after she approached the honorable court on 2018 after the 5 years.
Now, when was Jharkhand court approached?
2018. Sir. That is page number 47. Sir. Case number 3219 of
47.
2047 of this petition. Sir, there was no explanation of her delay in filing that the withdrawal of the
Just a minute, please.
Yes.
Okay.
That is about delay 90 days, that is fine, but until he approached the honorable court after 5 years of exceptional resignation.
Okay. Okay. Yes, how do you explain your delay first approach to the Jharkhand High Court in the year 2018?
My lord, last communication with regard to withdrawal of my lord resignation is dated 11/3/2015. That is case 46.
Now, from 15 to 18,
My lord.
no, this is the rejection of your representation.
My lord, my lord. There are,
Cause of action has arisen
my lord,
in 2013
my
when your application for re-employment was rejected.
Right.
Thereafter, by filing a representation, that will not lead to an automatic extension of the cause of action. Have you explained anywhere why 5 years to approach even the Jharkhand High Court? And why in the writ petition you have not said anything about your illness? If you think that illness is
Yes.
one of the grounds which should be taken into consideration. First, in your re-employment, the fact of your illness has not been mentioned, which is very important. We have seen that in the High Court, the Jharkhand High Court order, there is no reflection of the.
Right.
Then forget about those. At least in this writ petition, there should have been a pleading. And the medical documents, we have also had a cursory glance. These are for period 26/8/13 to 28/13, which is after the period of 90 days.
no, my
It's just 2 days before. Doesn't make a difference.
Okay.
If you go very technical,
No.
29/5 was the date. You are in medical certificate says that 26/8.
But my lord, is our case. The resignation was submitted on death provocation due to my lord family problem. And ultimately, she could not, my lord, save her marital life.
No, see, that is the only reason why 90 days time is given for reflection.
Yeah.
Even if we assume that the instant acceptance of the resignation is not in accordance with law,
Yeah.
but after expiry of 90 days,
Yeah.
the instant acceptance becomes final. Even if there was any aberration in law, that gets cured after completion of 90 days. And the reliance on the office memorandum by you and the CRPF rule does not appear to be an accepted proposition because we do not think that CISF rules are vague. It is very clear. And that office memorandum where you say that by which there can be a case where there can be condonation, it says 3 things. And all the 3 things have been taken into consideration. Number 1, that it has to be within 90 days. If not, if it is beyond 90 days, the period should be a marginal one. Number two, the acceptance of such an application has to be under exceptional circumstance. Wherein you make out a case, you have not made out any case. Your re-employment letter, which you have not annexed, is just 3-4 sentences. And you have not made any statement with regard to the public interest aspect. There is another aspect of public interest, that your induction back into the service would be in the public interest. That part is also one of the facets of this office memorandum, which you have not taken into consideration.
My submission, I have completed my training. I was also discharged duty for 5 years. So, my lord, it will be beneficial for the state also that I could be absorbed without training or cost of training. That is also one aspect.
And one more question which we are yet to put to you, that the acceptance, provisional acceptance was attached with certain conditions.
Nice.
You fulfill those conditions.
Understand that.
If you would have come to the court that the conditions I have not even fulfilled, so how do you make the provisional acceptance or final acceptance? Those are certain things which by which your conduct is exposed. You wanted to be your relations to be severed with the organization, which was done. 90 days over, then suddenly you come up.
But my humble submission before your lordship is that, my lord, that was an under impelling situation.
That
my
compelling
principle.
circumstances, situations have to be pleaded not
My
in the
lord.
court, before the authorities. And if they take a call that no, we do not think these are exceptional circumstances, then those could be matters of examination. Now, what will you examine? We will examine the order which has been passed on the face of it, along with the materials which were before them. We do not find those materials were there. Okay, right. Okay, you have tried your best, Mr. Das, but we cannot help. The rejection of the prayer of the petitioner for withdrawing her resignation from service is the broad subject matter which has been raised in this petition filed under Article 226 of the Constitution of India. Full stop. The facts in brief may be stated as follows. Para. The petitioner was appointed as a constable in the CISF, Central Industrial Security Force, within bracket herein after CISF, on 28/2008. And after completion of training, she was posted at Kota, Rajasthan, vide an order dated 16/4/2009. Full stop. On 11/9/2012, no, from 11/9/2012 to 8/11/2012, the petitioner was on leave. And in the meantime, on 14/9/2012, an order of transfer of the petitioner to Dibrugarh was passed. Full stop. Para. On the issue of overstay of leave, a departmental proceeding was initiated against the petitioner, which had culminated in imposition of a penalty of reduction of pay for 3 years. Full stop. Though such action was not put to any challenge, comma, it has been pleaded that due to certain domestic problems, comma, on 28/5/2013, comma, the petitioner had submitted her resignation. Full stop. The same was provisionally accepted via a communication dated 29/5/2013, and on the same date, the petitioner was discharged. Full stop. On the next date, that is 30/5/2013, comma, the name of the petitioner was struck off from the rolls of the CISF. Full stop. The provisional acceptance was, however, attached with certain conditions which the petitioner had fulfilled. Full stop. Para. It is the case of the petitioner that on 1/11/2013, comma, she had submitted an application for withdrawal of her resignation, which, however, was rejected on 29/11/2013 on the ground that the same was submitted, the same was not submitted within the prescribed period of 90 days, and there was a delay of 65 days. Full stop. On such rejection, comma, the petitioner had submitted another representation dated 11/7/2014 before the Director General, which was also rejected on 22/7/2014. Full stop. Subsequent representations said to be filed by the petitioner were also rejected. Full stop. Para. In 2018, comma, the petitioner had approached the Honorable Jharkhand High Court by filing a writ petition being WPS, we didn't make it S, 3219 of 2018, challenging the action of rejection of her application for withdrawal of resignation. Full stop. The Honorable Jharkhand High Court, however, via order dated 14/2/2019, had rejected the aforesaid writ petition on the ground of territorial jurisdiction. Full stop. However, comma, pursuant to the liberty granted, comma, the instant writ petition has been filed. Full stop. Para. I have heard Sri U.K. Das, Learned Counsel for the petitioner, whereas the respondents are represented by Ms. A. Gayan, the Learned CGC. Full stop. Sri Das, the materials placed before this court. Sri Das, the Learned Counsel for the petitioner, has submitted that the acceptance of the resignation, though provisionally, was done on the very next date, that is 29/5/2013, which was hasty and not proper, whereby the petitioner was deprived of an adequate opportunity of reconsideration of her action. Full stop. Reliance it is further submitted that though an office memorandum dated 4/12/2007 was taken into consideration as a ground for such rejection, the said office memorandum also provides for condemnation of delay in inappropriate cases. Full stop. Para. By drawing the attention of this court to the Central Industrial Security Force Rules 2001, which were framed under Section 22 of the Central Industrial Security Force Act 1968, the learned counsel for the petitioner has submitted that the relevant provisions would be Rule 58 and 59. Full stop. Rules, it is submitted that while Rule 58 pertains to resignation, Rule 59 is with regard to the discharge certificate. Full stop. By drawing the attention of it is submitted that though Rule 59 envisages that the discharge certificate should be in a particular form in Appendix D inverted, the same was not complied with, and therefore the process cannot be held to be legal. Full stop. Reliance has also been placed on Rule 77, as per which, so far as conditions of service are concerned, if no provision or insufficient provisions have been made in the rules, the rules for a corresponding post in central government can be taken into consideration. Full stop. By submitting that Rule 58 of the aforesaid rules are insufficient, the learned counsel has contended that the CRPF rules of 1955 would come into application. Full stop. By drawing the attention of this court to Rule 17 of the CRPF rules, the learned counsel submits that the same is with regard to discharge. Full stop. Reference has also been made to the CRPF Act of 1949, more specifically, Section 6 thereof, which is with regard to resignation and withdrawal. Full stop. It is stated therein that such withdrawal has to be, such resignation is only envisaged within the first 3 months of service, and thereafter the withdrawal from service will have to be with prior permission of the authorities. Full stop. Reference has also been made to the schedule of the CRPF Act, which pertains to recruiting ROL, full stop. A recruiting role, and it is submitted that the same would apply in case of discharge. Full stop. Para. The learned counsel for the petitioner has also referred to the CRPF guidelines dated 17/5/1990, wherein certain conditions have been attached in case of acceptance of resignation. Full stop. It is reiterated that since the guidelines in the CIS Act and the rules are insufficient, the provisions of the CRPF Act and the rules would be applicable. Full stop. Para. 3. Thus, the learned counsel has also added that there were difficulties in the matrimonial life of the petitioner, and she was also having certain ailments. Full stop. It is submitted that though the medical documents could not be annexed in the petition filed before the Jharkhand High Court, such documents are placed on record in the present proceeding. Full stop. It is submitted that even the OM dated 4/12/2007 contemplates about the power to condone the period of 90 days, no reasons have been cited for not exercising the said power. Full stop. He has also submitted that the delay of 65 days is marginal. Full stop. By drawing the attention of this court to the affidavit in opposition filed by the respondents, numbers 1 to 6, dated 19/6/2020, more specifically, the averments made in paragraph 2 thereof, the learned counsel for the petitioner has submitted that the 3 grounds cited purporting to defend the impugned action are not sustainable in law. Full stop. He accordingly submits that the writ petition may be allowed an appropriate relief be granted to the petitioner. Full stop. Para. Per contra, comma. MS A. Gayan, the learned CGC, has submitted that the initial approach of the petitioner to the Jharkhand High Court in the year 2018 was itself a belated approach, as the cause of action, comma, if any, had arisen on 30/5/2013. Full stop. It is submitted that though liberty has been granted to the petitioner to approach this court, comma, the present approach has to be examined from the point of the merits, examined on its own merits. Full stop. By drawing the attention of this court to the application for resignation dated 29/5/2013, file submitted by the petitioner, comma, Ms. Gayan, the learned CGC, has contended that certain reasons were cited for offering such resignation. Full stop. While accepting the said resignation, though provisionally, comma, 5 conditions were attached, which were fulfilled by the petitioner, whereby the conduct of the petitioner, which appears to be consistent with her application for resignation, becomes evident. Full stop. It is submitted that even the communication dated 29/5/2013 of provisional acceptance had 3 further conditions, which included a clearance, and accordingly the name of the petitioner was struck off and copy of the same was given to her. Full stop. There was no objection of any nature from the petitioner, and only on 1/11/2013 the application for withdrawal of the resignation was submitted, by which time, comma, the 90 days period was already over. Full stop. Though the application dated 1/11/2013 has not been annexed to the writ petition, comma, Ms. Gayan, the learned CGC, who is in possession of a copy of the application, has submitted that there was no details in the said application, and it was a simple application only for withdrawal. Full stop. It is submitted that when the petitioner did not cite any acceptable and cogent reasons for withdrawal of a resignation, comma, the rejection of the same cannot be faulted with. Full stop. Para. As regards the grounds of ailment taken by the petitioner, comma, it is submitted that there is no such ground pleaded in the writ petition, and only in the rejoinder affidavit such ground has been taken by annexing certain medical certificate, full stop. By referring to the medical certificates, comma, medical documents, comma, Ms. Gayan has pointed out that even the period would show that it is beyond the period of 90 days, as the period is reflected from 26/8/2013 to 2010/2013. Full stop. Para. Ms. Gayan has further submitted that there is no occasion to fall back upon the rules, act and the rules of the CRPF when there is no ambiguity or insufficiency in the CISF Act and rules. Full stop. Para. The rival submissions advanced have been duly considered, and the materials placed before this court have been duly examined. Full stop. It is not in dispute that the resignation was submitted on 28/5/2013 by the petitioner. Full stop. Though such resignation was accepted on the very next date, that is 29/5/2013, comma, it was a provisional acceptance with which certain conditions were attached. Full stop. Fulfillment of those conditions, including refund by the petitioner, would show the consistent conduct of the petitioner with her decision to sever her relationship with her employer. Full stop. The entire action, including the communication dated 30/5/2013, by which the name of the petitioner was struck off, was done in a transparent manner, and in spite of the petitioner being fully aware of the same, comma, she had applied for withdrawal of her resignation only on 1/11/2013. Full stop. The application for withdrawal which has not been annexed to the writ petition full stop. However, comma, on a copy being produced by Ms. Gayan, the learned CGC, comma, it is seen that no details or reasons for such decision has been conveyed. Full stop. The application for withdrawal of resignation was rejected on 29/11/2013. Full stop. Though representations were submitted which were also rejected, comma, this court is of the opinion that subsequent filing of resignation would not extend the cause of action. Full stop. The approach of the petitioner to the Jharkhand High Court in the year 2018 itself raises a serious question on the bona fide of the petitioner to actually raise the issue. Full stop. Ms. Gayan, the learned CGC, is correct in contending that though the Honorable Jharkhand High Court had, while rejecting the said writ petition on territorial grounds, had granted liberty, comma, the merits of the challenge are to be gone into. Full stop. Para. The provision in the CISF rules pertaining to resignation and discharge are explicit and is not held to be insufficient in any manner, and therefore the contention of the learned counsel for the petitioner to take into recourse Rule 77 is not accepted. Full stop. Para. The reasons cited in the impugned order dated 1/11/2013 are mainly threefold. Full stop. Firstly, comma, it has been held that the application has been filed beyond 90 days, which is the prescribed period. Full stop. Secondly, it has been held that no case of exceptional nature has been made out. And thirdly, comma, there is no element of public interest for accepting such withdrawal application. Full stop. The aforesaid reasons, comma, in the opinion of this court are found to be cogent and acceptable, and this court, in exercise of the certiorari jurisdiction, would only examine the decision-making process, which in this case appears to be done in a fair, transparent, and reasonable manner. Full stop. Para. With regard to the insufficiency of the grounds in the application for withdrawal of resignation, comma, this court has also seen that no grounds as such were cited in the application dated 1/11/2013. Full stop. The ground of illness appears to be clearly appears to be an afterthought, inasmuch as such grounds were admittedly not taken in the petition before the Honorable Jharkhand High Court, and even in this writ petition, and only in the rejoinder affidavit, comma, such ground has been taken.
These documents are annexed before the Honorable Jharkhand High Court, but not in the. That was my sub. Although submitted there.
We have said in the writ petition. Also, though rejoinder affidavit may be held to be a part of the pleadings, comma, the medical certificate is of a date which raises serious doubts on the grounds tried to be set up by the petitioner regarding her illness. Full stop. Para. In view of the aforesaid facts and circumstances, comma, this court is of the considered view that no case for interference is made out, and the acceptance of the resignation as well as the rejection of the withdrawal dated of the opinion that the order dated 1/11/2013 by which the application for withdrawal of the resignation has been rejected appears to be fair and reasonable, and therefore this writ petition is dismissed.
My lord, order dated 29/11/2000 regarding refusal, rejection of my lord Actual petition.
No, no, we have not said representation. We said,
No, my lord, order dated 29/11/2005. That's it.
what is it?
Whereby rejected, my lord, the withdrawal application.
29/11, correct.
29.
29/11,
Right.
1/11 now,
Right.
29/11, correct.
Obligatory.
The petitioners are, my lord, the teachers, staff, like UDC, LDC, driver, peon of this Foodcraft Institute.
Foodcraft,
Craft Institute, which was constituted, my lord, in the year 2010 under the regulation
government of Assam.
government of Assam and India in collaboration. That your lordship will find the MOU and the rules and regulation at page 18.
Page
18,
18.
18. It starts from page connector 1, 18. That is MOU and rules, nothing to do with the present problem, my lord.
No, this Foodcraft Institute is what is the legal,
That is page 18, your lordship will find.
what is the legal status?
This is an institute, my lord, formed by the government of Assam and government of India for the purpose of
It is a society.
society. Government
Huh?
government society, its members are, my lord, page 28.
Wait.
They are the members. Executive shall be the finance committee of the so-and-so, the director of tourism, managing director so-and-so, secretary finance, one of the members of the Hotel and Restaurant Association of Assam, to be specified by the state government. Rule 19, my lord, Director, National Council for Hotel Management, Principal of the Institute, ex officio, Director, Tourism, so they are the executive committee members.
Yes.
Okay. Page 23, your lordship will find the page membership, my lord.
23.
Rule 4, my lord. Society shall consist of chairman, principal secretary, tourism, 2 representatives of the central government from the Ministry of Tourism, 3 representatives of state government from Department of Finance. So Director, National Council for Hotel Management,
Okay.
1 member from the hotel. I have already read the thing. Principal of the Institute of Experts, state government may nominate not more than 2 experts to be members of the society. And page 31. Subject to the prior approval of the state government, the society may 28, member. Rule
Yes.
28. subject-
Alterations.
Yes. So all government control for all purposes. So
Okay.
now this is the position, my lord. Page 36, your lordship will kindly say.
36.
36.
Yes, please.
This is a minutes of the second meeting of the Board of Governors. Relevant is that page, these are all government tourism, government official fund. Page 37. 1.1 or 1.01. The board approved the post created and also observed that the post should be advertised with the corresponding revised pay, not revised pay scale in terms of the Assam Services ROP rules 2009. The Director Technical Education suggested that the pay scales of the faculty members could be considered in lines of the pay scales of the Polytechnic Institute or in Assam. This Polytechnic, your lordship will kindly note this Institute of Assam, we are at par with them. The board took note of this and directed the principal FCI to consult the Director Technical Education on this matter and on the qualifications of faculty members as per the revised rules of the NCH MCT New Delhi. 1.02 approval. The board approved the post created and also observed that the post should be advertised with a corresponding revised pay scale in terms of the Assam Services ROP rules. So accordingly, my lord, this petitioner, your lordship will see, kindly see my lord, page 8.
8.
I've given a chart. Page 8 and 9. These are the names and posts concerned.
At 9.
Yes. So these persons are lab assistants, peon, driver, LDC, UDC, and 4 lecturers are. On the basis of the
There are
advertisement.
14 petitioners.
14 people. So accordingly, my lord, they were appointed on the basis of the advertisement and selection, and they were given the benefit of 6 pay scale. 6 ROP, 6 pay commission, my lord, benefit. That your lordship will find at page 64. Now, this, if I read, my lord, the whole case is covered.
Page 64.
4. It is written by the Principal Foodcraft Institute to the Principal Secretary to Government of Assam Tourism Department. May I read, madam?
Yes, please.
With reference to the above cited subject, I am to bring a kind attention notice that the Foodcraft Institute had commenced its academic session in the year 2010, where our pay scales were fixed as per recommendations of the 6th Pay Commission. However, we are still under the 6th Pay Commission, because of which there is gross disparity between our pay scales and pay scales of other employees of state government, employees or other state government society, corporations, and it's not only causing great financial inconveniences to us, but also having a demoralizing effect on the employees who have been serving the institute in a dedicated manner over this year. The Foodcraft Institute has a full student capacity of 140 numbers in the 1.5 year diploma course that is conduct and which are affiliated to National Council for Hotel Management and Catering Technology under the Ministry of Tourism, Government of India. However, each year, in spite of sincere and earnest effort by the institute to attract potential candidates, there is also always a shortfall of students, perhaps because of the isolated locations of the institute. Moreover, the fee structure of these diploma courses are very low, and because of this, even if we have full capacity intake of students, there is still a deficit budget, and we need to rely on the state government grants for our salary and maintenance. This year we have student intake 121 number out of, while 19 are direct paying students, while the rest are sponsored by various governments. So, my lord, skip one or two paragraphs, my lord, and sir, all the permanent employees are serving in the institute since 2010, while the principal since 2009, and over the years have built a favorable reputation in the hotel industry across the country by producing well-trained manpower. However, we are still on 6 pay commission as we are not generating sufficient revenue to meet the salary and other administrative expenses because of reasons already mentioned above. Our institute is a welfare institute and not a profit-making organization, and we offer skill development and job-oriented courses which are highly demanded in the hospital industry. Last paragraph, my lord.
Hospitality.
Yes, hospitality industry. A petition submitted by the employee of the Foodcraft Institute is enclosed herewith. In view of all
There was
the
a request to
reasons,
give the benefits of 7 pay.
7.
Okay.
This is what it is. Now, page 66, your lordship.
66. Board meeting,
Board meeting,
date 7/1.
67.
7/1. 7/1/21.
Yes,
Board of Governors meeting.
finance, page 67, my lord.
67. Yes, please.
67, and 68, it will continue. Board of Governors noted the matter of head creation under so and so. Last, the last paragraph. The principal Foodcraft Institute informed the Board of Governors that the institute has fund available to bear office expenses, including electricity, interest, training, food process, etc., up to 21. Regarding petition from the staff of Foodcraft Institute for revised pay scale, the Board of Governors stated that since the salary is being paid out of state government grant, approval from Finance Department has to be taken for revising the pay scale. Principal Foodcraft Institute informed the board to Board of Governors that a proposal for pay revision was submitted to the Department of Tourism to Finance Department and is under process with Finance Department. Joint Secretary Srimati so-and-so was advised by Chairman to look into this matter and inquire about the status of it. So ultimately, they say is, what they say is, Malad, I have stated in paragraph 18, employees of Polytechnic Institute have already been provided the benefit of 2017 ROP. Paragraph 18.
Which page?
Page, Malad. Have been considered at par with the service of the Polytechnic Institute of Assam. They pointed out that the employees of the Polytechnic Institute have already been granted the benefit of ROP
Okay.
2017. So we are also, now in their affidavit, what they say is, Lord, if your lordship will come email at this. Finance Department affidavit directly, I will take your lordship. I think your lordship will get that page. 74. That is the part of the affidavit filed by Joint Secretary Tourism Department.
Mhm.
Same thing has been on page 74.
Who is the deponent?
And he's the Joint Secretary,
No, deponent. Name?
Dipankar Das.
Well, that is not 74. That is,
His page starts from
that is
page
70. 70.
70.
Yes.
This is the part of the 74 is the part of the affidavit.
AIO
Annexure.
by, this is by respondent number 1.
Yes.
Dated
So-
25/11/2021. You are at which page? 74.
Yes, my lord, your lordship will kindly see page 73
73.
from to so and so with reference to your letter on the subject cited above. This is from the Deputy Secretary Tourism to my lord Principal Foodcraft Institute. In reference to your side, I am directed to inform that the Finance Department regrets your proposal for extending revised pay scale as per rules 2079 to the employees of the Foodcraft. It is advised by the Finance Department that such submissions may be made only at the outset of next mechanism for pay revision or any other mechanism adopted by the government from time to time. Now, this is the note, my lord, page 74. This is Deputy Secretary Finance rule. Page 74, second paragraph. Finance Department observes that there being no such recommendations of the 7 pay. My lord, 7 pay recommendation, my lord, we cannot go and have it, my lord. It has to be placed by the Tourism Department. I think they could not place it on time, and the employees are now getting the not getting the benefit. This is the note of the finance. Finance Department affidavit, your lordship will get it at page 75. Paragraph 4.
Finance affidavit.
Yes. As regards statement made, deponent begs to state that in the year 2018, the Tourism Department has submitted a proposal to the Finance Department for extending the benefit of revised pay scales in respect of employees of Foodcraft Institute as per 2017 rule. In response to the Tourism Department's proposal, the Finance Department regretted the proposal of the Tourism Department by the department endorsement dated 9/1/2020, which I have read. Further, the Tourism Department was advised to make a proper submission at the time of start of the next mechanism adopted by the government for pay revision or whatever dedicated mechanism of the government is put in place in the due course of time. However, no communication proposal thereafter has been received by the Finance Department. So this is the my lord, point taken by the Finance Department. And
We will come back at 2.
So, my lord, the whole issue is at page 77 on. And they have not taken a resolution, a decision whether the petitioners are entitled to get a benefit of 7th pay commission. And they are similarly situated at Polytech Institute, they are getting it. So they should take a decision on it. Proper proposal has to be sent, my lord.
Mr. Das,
They cannot be deprived.
Mr. Das, page 77,
Yes.
paragraph 4, the
Yes.
last line says that
Yes.
Finance Department on principle has not negated your
Not negative.
claim.
not negative.
They have only said that it was not submitted in the proper time.
Proper time.
But till the date of filing of the affidavit,
Yes.
even the Tourism Department has not submitted.
Yes.
Yes, you represent the Tourism Department, you submit it. At
Let
least
them submit it.
let there be a culmination of the process.
Yes.
The process
they
is on
should-
the midway.
They- Now the 7th Finance Commission is gone.
Hmm.
If we follow the Finance Commission's that note, that means you submitted at the time of 8th Finance Commission.
Yes, that the
8th
next
Finance
mechanism-
Commission, they will not take into consideration the benefit of 7th Finance Commission. That is not there. I have found 1 or 2 judgments which is where the court interferes when there is violation of Article 40. There cannot be, one unit is getting, we are at par with Polytechnic Institute, and we have been given the benefit of 6-pay scale, 6-pay benefit commission. And why should we be deprived of 7-pay commission's benefit?
Is
So they-
finance a party here?
Yes, finance has filed an affidavit.
Where is
This affidavit
finance?
is that is at page 80, I think. Page 80. Sorry, madam. Page 75.
Is that we have seen 77 part?
77 and that note is at page 17. Same note,
Yes.
they said when
Who
the
is now Finance
mechanism.
Department?
This, on the. In fact,
Chaliha.
Yes, yes.
But the ball is not in the Finance Department now. Ball is
Now
in your
it is
court.
Yes, yes.
You
Because
have to submit a proposal, let the
Let
Finance
them
Department.
submit proposal and they will take a decision in comparing the benefits given to Polytechnic. Otherwise, they will be deprived of the benefit.
See, on principle, are you?
Yes, 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 no, we are not that we are not giving. Only thing is that we have missed the path. Now, as they have not, perhaps not paid, so there's no such recommendation.
But this affidavit is of
2021.
2023, I think August.
Our affidavit of 2021.
21, from 21 to 24.
First of all,
Your affidavit, leave aside for a moment your affidavit. Finance Department in its affidavit in August 2023 says that till that time, no proposal was received from Tourism Department. Till that time. So at least that is the later point of time which we'll consider. So you need to submit the proposal.
That's what I see, Lord.
Nobody is against giving the benefit of. They say
No,
there was some delay.
that was the only consideration or doubt in our mind, that whether on principle they are agreeing with you or they have some other objection.
They are agreeing.
Since they do not have any objections,
Yes.
I think we can pass directions for you to submit the necessary
Yes,
proposal.
yes, yes.
And they will consider within a stipulated. In comparison with.
Otherwise,
Polytechnic-
when is the time? What is the time
10
specified?
years, I think,
10 years,
No, when the finance department note says that it should be given in a particular point of time, what is that?
No,
time?
that time, as per our affidavit, the annexa number 2, there's no such time has been mentioned within this annexa 2 of the middle.
Neither here nor there.
At the time of the start of next mechanism adopted, when is this?
10 years.
I see next mechanism is pay commission at 8. Then it will be 2027%.
Mr. Das, can you just throw some light on page 79, the second last paragraph? That note.
Yes.
As such,
Tourism Department is advised to make a proper submission at the time of start of next mechanism adopted by government for pay revision. That is.
or
whatever dedicated mechanism the government puts in place in due course of time. So last line, my lord, I think your direction has to go from your law,
no,
because they are not sure of it.
whatever dedicated mechanism.
The government puts in place in due course of time. And it's a vague thing. Man.
So when is this going to happen?
This is, I mean,
Start
there is
of
no
next
such-
mechanism or
whenever.
dedicated mechanism?
This is, there is no.
Can you
such
have
thing.
Mr. Chaliha or anyone from the finance department? Oh.
My lord, Financial Commission has note, I must say with due respect, my lord. It's not clear that you will not get it, or you will get it at the 8 finance commissions. 8 finance commission will never compare and never consider, my lord, 7 finance commission bill.
True.
So it has to be taken by the finance department.
But your principal appears to have given the representation in time to the department.
In time to it.
Department have not
There is a
forgotten.
lab. And it is not that the finance commission's recommendations, etc., are not interfered by the court.
Mr. Chaliha. You have the brief of this matter? Okay, this initially when senior council started, we thought there may be some dispute or issues with regard to their entitlement. That is not the issue. That dispute is not there. The employees of Foodcraft Institute, their claim to get the benefit of pay revision is more or less admitted. Now, your stand is that the submission was not given. Until the time of filing of the affidavit, no such submission. And the first submission by the tourism department was not in the proper time. There is one paragraph, if you come to page 79 of the paper book, which is a part of your affidavit. If you have your affidavit, annexure
Yes.
Finance Department
Got
affidavit.
it.
Internal page would be around 5 or 6 maybe. Have you got that
Yes,
note?
got it.
If you come to the third last and second last paragraph,
Got it.
please read against.
Against this backdrop, Finance Department observes that there being no such recommendation of the seventh company committee for allowing revised pay scale as per ROP 2007 to the employees of Craft Samugui Nagaon. Finance Department regrets the proposal regarding sending revised pay scale as per ROP rules 170 to employees of Craft Institute Samugui. As such, Tourism Department is advised to make a proper submission at the time of start of next mechanism adopted by the government for pay revision or whatever dedicated mechanism the government puts in place due course of time.
You also read the paragraph prior to that, after publication.
After publication of ROP, the existing mechanism provides another opportunity for redressal of any genuine grievances to anomaly.
See, you know the process. There is a revision of pay followed by an anomaly commission.
Right.
Whoever has any grievance can approach the anomaly commission. The anomaly commission will look into it and ultimately the final revision will be done. Here it appears that neither it was taken up in the revision nor in the anomaly commission because there was no submission.
Yes.
Now you have said that on principle you may not have a difficulty in considering,
Yes.
provided the proposal comes
Yes, sir.
in the due course from the department. Now, what is the time? This we are slightly not very clear regarding the time. Advised to make proper submission at the time of start of next mechanism adopted by government for pay revision or whatever dedicated mechanism. You are meaning the revision as well as the anomaly commission. So which one? When will the submit?
Lordship, that I think my limited knowledge, Lordship, I think the next committee for the revision of pay will be considered somewhere in the year 25. So I think it's somewhere nearby, but I'm not get that the exact date, Lordship.
Now, since their entitlement may not be in dispute, only for the reason that the department did not raise the issue
Yes.
properly or in proper point of time,
Yes.
should they be deprived of the entitlement or claim under the 7th revision? Now
Yes.
the 8th revision will come.
Yes, sir. The 8th revision of pay that can be considered provided the mechanism already initiated from the.
But they are also claiming the revision from the 7th commission.
Yes, sir.
7th they have been deprived of.
6th has been given.
6th they have already got.
Yes, that can be considered when all these issues are propped up in the 8th. Lordship, but yeah, but all these facts because it was
Now,
never.
8th commission consideration may also consider their cases
Yes.
of the employees of Foodcraft Institute
Yes.
because they stand in an exclusive footing.
Yes.
They are claiming parity with employees of polytechnics.
Yes.
In fact, there are materials on record which they are to be deemed at par.
Okay.
So if they are deemed at par and polytechnic employees are getting the benefit of revision only because of the fact that the submission was done properly in due course of time,
Yes.
in the proper point of time. They are being left out because it was not submitted by the tourism department.
Yes.
Now, we direct the tourism department to submit.
Yes.
They submit, but why not be the consideration? It cannot be out of the context.
Yes.
Pay revision cannot be for a person, individual or for an organization. It has to be for the state as a whole. First the revision, then the anomaly commission.
Yes.
So when do you have it?
That date I not
This writ is pending since when, Mr. Das?
21.
21.
So Lordship, grant me a short date, Lordship, if Lordship is on Friday.
No, we want to pass final orders. We can have it tomorrow
Tomorrow, yes, Lordship.
because we have heard it and we
Yes, Lordship may have it tomorrow. I can.
see orders of this court. We don't like to pass orders which cannot be implemented or would be implemented after indefinite period of
Yes.
time. If you want to give some time frame, then it also have to be in conformity with the law. Pay commission cannot be for a specific
Yes.
individual. And if you actually consider their case in 2025, then their entitlement for getting the benefit of 7, what is your take there?
All those factors have been.
So, see, the question would ultimately boil down of the benefit. When they get is another question.
Got it.
But if the backlog or whatever their claim for 7, there it is also released under the 8th, your purpose would be served perhaps.
Yes. Lordship may have it on Thursday,
Mr. Das, let him have the instructions.
yes, but Thursday.
Otherwise, we are very
Yes,
clear.
yes, what, the whole crux is, they should not be deprived, since the government has also agreed. Now, the only thing is that they have missed the pass, that's what they say. It cannot be like that.
Okay, okay. Heard. Sri B.D. Das, learned senior counsel. Assisted by Sri Laskar, M.H. Laskar, for the petitioners.
Yeah.
Had also heard Sri C.K.S. Barua, the learned state counsel, as well as Sri A. Chaliha, the learned standing counsel, finance department. Para. After hearing this matter at some length, Sri Chaliha, the learned standing counsel, prays for a little accommodation to seek instructions specifically with regard to the time when the mechanism for revision of pay would be adopted by the government or any other dedicated mechanism for the said purpose, as reflected in the note sheet dated, is it 9/1? 9/1/2020, annexed as annexure in the affidavit in opposition of the finance department, full-stop para, as agreed to by the learned counsel for the parties. List on Thursday.
4/4.
4/4. Oblate. এইটো মোৰ লৈ যাব পাৰিলে হয়, এইটো মোৰ টেবুলত দিলে হ'ল হা, এইটো মই মোটামুটি হেৰিটো দিয়ে থৈ দিম।
কিনে রাখছো তাতে এই কার্টন দুটো আছে না কার্টনটা আছে না তাতে আছে না